We now come to the session where we hear evidence from the Magistrates Association.
Well, I hadn't.
Thank you very much for having us. Thank you so much for having us.
Could I thank our witnesses from the Magistrates Association for coming before us this morning, and may I invite you both to just introduce yourselves to the committee, and if you'd like to make a brief introductory statement, that would be most welcome.
Good afternoon, everyone. I'm John Fassenfeld. I'm Deputy Chairman and Chairman-elect for the Magistrates Association.
Good afternoon, everybody. I'm John Thornhill. I'm current Chairman of the Magistrates Association, only for another 4 months, I think it is, John, isn't it? And I sit in the Liverpool City Magistrates Court, so it's quite a busy bench, and we see a wide range of cases there. I would like to make a brief statement, Mr. Chairman, if that's all right, and say we're very delighted to be able and to have been invited to come and give evidence before this committee today, and to assure you that we will continue to engage in debates and discussions as the bill processes through the various stages finally to enactment. Many of the proposals in the bill resonate with our views, and those views reflect our response to the Green Paper, especially issues in relation to wider powers in dealing with young offenders, and John has expertise in youth courts, and in dealing with those who breach court orders. There are 3 specific areas on which we would like to have further debate and discussion, as they raise some concerns for us. One, of course, as you will expect, is the restriction on remanding in custody pre-trial. Secondly, the wider discretion for out-of-court disposals, given some concerns that we have about their use, and indeed the recent Chief Inspector's report, and also the repeal of Section 154 of the 2000 Criminal Justice Act, which would have given magistrates 12 months for a single sentence. We know that it is argued that that's put in the context of Custody Plus, but certainly our information is that it was very much a separate entity as a clause within that particular bill, not tied in with Custody Plus, and we would like to see that particular clause actually taken out. And we support many of the principles about victims and witnesses that we've heard already today. So that's our brief statement, Mr. Chairman.
Elfyn Flood, Dave Watts, Kate Green.
Thank you. Mr. Thornhill, you've highlighted your concerns about the changes in bail. Can you tell us a bit more about your concerns in that regard?
Yes, the issue here really is very much about giving and allowing judges and the magistrate to retain discretion where it is appropriate. The issue of sentence is about offence and offender. The issue of bail is evaluating the risks that the offender may not turn up or may commit further offences whilst on bail, or importantly may interfere with witnesses or victims. And so we believe that we really need to retain the right on occasions to impose a remand in custody. We do appreciate that very often many of those offenders do not receive a custodial sentence in the long run. But I think we also have concerns about effectively saying at the very beginning, when we're only looking at the risks the offender poses, whether they will receive a custodial sentence or not. We do not wish to in any way give an expectation to the offender that because they have been given granted bail, that they can therefore assume that they will not receive a custodial sentence if the risks posed by that offender would be risks where we felt a remand in custody was appropriate.
In other words, it's not just simply whether there's a custodial sentence on the horizon, it's to do with, amongst other things, the possibility of an interference with the judicial process.
That's exactly the point that we're making. As I said, we need to separate the sentence, which is down the line, from the risks posed by the offender. And we do not really look at the sentence. What we look at is, will the offender turn up? Might they commit further offences on bail, particularly if there is a history in their record of so doing? And Might they interfere with witnesses? Even though the offence itself may not receive a custodial sentence in the end, they are, for us, two separate issues.
Can I just add, as far as youth court magistrates concerned, I've been a youth court magistrate for many years. It is a necessary weapon in our armoury, particularly for young people who are out of control, that may not be sentenced to custody in the end. I see many youngsters that are out of control, that are in dangerous situations, that are mixing with an older group, that may be a drug pusher, involved in prostitution, and I think it's essential for magistrates not to be, their discretion, not to be tied in order to actually take these youngsters away from dangerous situations, even though in the end they may not actually end up in custody.
We could perhaps resolve the issue by having more bail hostels available, and that is very often the magistrates' hands are tied because the risks posed are such that we have grave concerns that they would turn up, etc. But if we had strong bail hostels where we could remand some of the offenders to, that would certainly help.
Dave Watts.
Can I ask you about these penalty notices and penalty notices for disorder? Isn't this an effective way of dealing with a problem? It seems to me that it's open to, first of all, perhaps some people with money being able to pay a quick fine and having no account whatsoever of the crime or the offence that they've committed. And in the second case, it could be the opposite way, where people are on such low income that the level of payment would be set at such a low level that they actually it wouldn't deter them. It seems to me that you can, whichever way you look at this, it seems the bill will make it even more difficult to actually for people to see justice being done.
I think that's the real nub of the issue. You will all know, of course, that we are required by the 1361 Act to impose appropriate and proportionate fines, taking account of the means of the offender to pay. That does not happen with a fixed penalty notice or a penalty notice for disorder. But that's not to say we do not accept that there is a place for these sorts of sanctions that the police can use. We appreciate the work the police have on, say, a busy Friday, Saturday evening, and they need something very quickly to diffuse a situation. But we need to look at this. Justice is about public justice, and fixed penalty notices for disorder, cautions, conditional caution, are not in the public eye. And we believe that we need to have a system whereby if we are going to use sanctions prior to a judicial sanction, then we have to have that in the public eye so that there can be confidence in the system. And so very often it does turn itself upside down. We're also concerned, from some of the examples we've seen, that very often the offenders accept the fixed penalty or penalty notice of disorder or caution as the quick and sharp resolution to a situation, which may well be appropriate, and we don't want to be spending more money than is necessary on serious offences, but sometimes are not aware of the consequences further down the line when they seek a CRB check for employment, and suddenly this comes up when they may not have been found guilty in a court.
I think the education requirements have to be looked at very closely and be careful with the guidance concerning that, because it could lead, given that it's the local chief constable's discretion, it could lead to some form of postcode justice. And certainly the examples of the individuals that I see in front of me haven't got the money to afford education provision.
Isn't there a likelihood the chief constables will want to use this to avoid so-called bureaucracy and paperwork, and that you may well have this being used for inappropriate offences in the future?
Yeah, I absolutely agree with you. And but I think what the chief constable's got to consider is that the introduction of such a system will, by the pure definition, bring on bureaucracy.
But we do accept that maybe there is a little bit too much bureaucracy at the moment, and we need to actually go back to first principles and pare some of it out. Because what do we actually need in court? And some of it is very simple, short, sharp statement of what happened.
Kate Green.
Thank you. Mr. Chairman, I should probably also declare an interest as a life member of the Magistrates Association at this point. I wanted to ask you about the proposals in the bill in relation to knife crime and whether you have any views on the extent to which that might now start to limit judicial discretion.
I think the proposals are to be welcomed by the association, and the difficulty we have is the 6 month minimum mandatory provision, although we accept that there is a clause in the bill which, in the interest of justice, allows us to change that. And I think we've got to be extremely careful in the application of this particular clause, and we've got to be careful that individuals can carry knives, and as the bill says, can carry knives as long as they can prove that it's part of their work, their necessity to have the knife in possession.
We can certainly appreciate the thinking behind putting the clause in, but it seems to go against the whole concept of the rest of the bill, which is about granting discretion to those who have a professional job to do, either the judiciary or Crown Prosecution Service or indeed probation officers. And it seems to be out of kilter with the rest of the bill in that way.
To what degree have you felt an insufficiency in your sentencing powers in relation to this matter up till now?
Well, I think the guidelines are very clear and very full, and in fact have given us wide powers to deal with different levels of knife crime.
Mike Rockhart.
We heard from the Victims Commissioner real concerns about the extension of powers to suspend custodial sentences of up to 2 years. I mean, do you think that you're going to use these new powers more, and what effect do you think that would have?
I think we've got to look at the context of this, and I think you, Mr. Chairman, talked about suspended sentences plus. If the principle is to talk about rehabilitation as well as punishment, I'm often left asking the question, what does a suspended sentence do in terms of rehabilitation without some sort of programme attached to it? And if an individual has committed an offence which merits a custodial sentence, for a variety of different reasons, the bench or the judiciary decide not to impose an immediate custodial sentence, but impose a suspended sentence. Now, if that offender has got serious underlying reasons for committing those offences, we're doing nothing about it. So it does seem to us that those suspended sentences, we should still have the right to impose attendant programmes. Now, clearly we need to look at the research that's taken place over the last 5 years in relation to the number of requirements imposed on a suspended sentence. But it does seem to us that we do need the opportunity to still say, fine, let's do some rehabilitative work with the offender, even though they're on a suspended sentence of custody.
But does this indicate then that you feel that there is something missing in your toolbox, if you like, that stands between a restorative justice in the community and a suspended sentence? Is there something missing there that you feel
I think
you cannot do at the moment?
I think in a way magistrates would say, well, look, give us a bigger toolbox with a wider range of tools that we can use in specific circumstances. What we're looking towards is looking at individualised sentencing. Now, of course, in every offence and with every offender, they can't have an individual sentence specific to just their needs. But if we have a wider range of tools available to us, we can begin to do that more constructively than we can do at the moment. Now, restorative justice, we have discussed this in detail. We've actually visited Northern Ireland and we've spoken to the Restorative Justice Council. And we would like consideration to be given to restorative justice being added to one of the specific requirements that we could include within a community sentence. Again, to be used in specific circumstances with specific offenders.
I would echo
John Fassenfeld.
John's comments, particularly at the top end, and I think this is where the youth court sentences are slightly out of kilter with the adult court sentences. Youth courts, one of the main reasons that youth court custody rates have gone down, I believe, is that there is an intensive alternative to custody. It's called ISSP at the very top end. That intensive alternative to custody, whilst it's been piloted in a number of areas in England and Wales, has not actually been rolled out over the areas. And I think, as John said, we need more weapons in those armories, in our armoury, to keep adults particularly out of custody.
Helen Goodman, Andy Slaughter, Alex Cunningham.
Thank you very much. I want to come back to what you were saying, Mr Thornhill, earlier about out-of-court disposals. I just want to see whether I understood what you were really saying. Were you saying that, particularly with fixed penalties, one of the problem was that they're not recorded properly and there isn't a proper track kept of it?
That's right.
Could you just say how you think that they should be recorded then?
John Thornhill.
It's a very difficult one, but very often what happens is we see an offender in court, brought to court, and it comes out by accident, either from the offender's own mouth that they've had a number of fixed penalty notices or penalty notice of disorder, but there is no record which we can then effectively take into account. We would like to see some sort of record. We're not looking for complicated records here, but it doesn't seem unreasonable if we have a police computer that can give us information that a caution can be not a caution, but a caution, FPN or PND, can be recorded on that. So it's available as part of the antecedents of the offender when they appear in the court.
Can I just add,
John Fassett,
for transparency's sake, for the community's sake, there has to be a record, and that record has to be shared with the community in order for the community to be able to gain confidence in some of these out-of-court disposals when they are used in the proper context.
So it's not just a question of keeping a private record, it's also a question of publishing the record.
Yes, absolutely.
Because, as I said, justice is public. And there are some elements of our justice system at the moment that are not public, and therefore the public cannot have confidence in the whole range of sanctions disposals that are available within the justice system.
You also said that you valued section 154 in the 2003 Criminal Justice Act. Could you say a little more about that? Please?
Yes, that gives magistrates 12 months for any single offence. And one of the issues that we're all concerned about is finance. And many of the offences that go to Crown Court could actually be dealt with in the magistrates' courts. There are a variety of ways of dealing with that. One of those would be to look at mode of trial guidelines. Another would be to say, with some offences, you could restrict the nature of the offence. For instance, at the moment, criminal damage under 5,000 is a summary-only matter to be dealt with by magistrates. Above 5,000 is an either-way offence. You might want to say you could look at doing that with, say, something like theft. I don't think we're saying that do away with jury trial at all, because that is a right that the citizen of this country has. But what we are saying is we need to look at how maybe in the magistrates' courts we could deal with more of the trials, because the cost of a magistrates' courts trial is significantly less than the cost of a Crown Court trial. We know the figures that of all the trials for theft in the Crown Court, 80% the value is under £200. And that's a figure which would mean that those offenders would be sentenced to a sentence which the magistrates could impose. So by keeping the 12 months, it would mean that we could deal with more serious examples of some of the offences that we deal with now, but would still be within the powers. We know that there are concerns that this might increase the custodial population, but we do have questions about the figures that have been given to us, and we would like to pursue those in detail. We would like to see that remain in the Act for further debate and discussion. Yes, take out the custody plus elements, because I think we always said we couldn't afford custody plus. Yet the concept of custody plus is something we ought to be looking at. That is, once the offender has served their prison sentence, they may still need help and support in the community to turn themselves around. Because whatever else we do, unless the offender is ready to rehabilitate themselves, we may well be working against them. So we do need to look at this and say we need to give support. The same principle applies there to suspended sentences. Put someone on suspended sentence for 2 years. If we don't do anything about it, at the end of 2 years, they may ready be to re-offend. But if we work with them, they may turn themselves around. So it's looking about what is rehabilitation about, And how do we do that? If we had that 12 months, we'd bring more trials from the Crown Courts, we'd deal with more matters in a summary way, and that would cut the costs significantly.
I think I would just add to that, the victim gain. Victims wouldn't have to wait so long for their Crown Court trials, and bearing in mind that they deal with the serious cases, so the victims on serious cases wouldn't have to wait so long because the backlog in Crown Court wouldn't be so great. Of course, more cases have been dealt with in Magistrates Court.
Andy Slaughter.
You said you don't believe that the withdrawal of the 12-month sentence for single offence is to do with custody plus, that it was a standalone provision. Do you know why it's going to be withdrawn? You still have, do you not, the power to sentence for 12 months on consecutively on different offences?
Yes, if there were two offences, we could impose 2 separate 6-month sentences consecutive.
So it can't therefore really be about your overall sentencing powers. Do you know why the government's taken the view that to withdraw that provision?
No, is the answer to that one, to be sharp.
Do you suspect it might simply be that they're worried that more people will go to prison for longer?
Well, we've had figures put to us that might be the reason. But when we actually questioned the figures, we noticed that the figures actually then reduced. But of course, the other issue is that in those figures that included those who elect trial at Crown Court, so therefore we have no control over that, but also included what we know is the fact is that when the matter goes to trial, the charge is changed. So sometimes a charge is changed from an either-way charge to a summary-only charge. So of course, if we'd actually pursued it further in the Magistrates Court, we might have got that charge put to us and therefore dealt with it without wasting the time and money at the Crown Court. So it does bear further investigation, and I don't think we should repeal that until we've further investigated it.
Indeed.
Andy Slaughter.
The issue of remand seems quite a fundamental change to the way that the criminal justice system works. That are magistrates very concerned about this? I mean, do they see it as a limitation on their authority and their discretion? Because effectively, a large body of defendants are going to come up in front of you, and you will accept in exceptional cases, have no ability, irrespective of whatever the risks you think there are, to remand them in custody.
I think there is a concern there. We're talking about the bail issue again. I think there is a concern because, as I said, we have to look at the merits, each case on its own merits and each offender on its own merits. And if we have a history of an offender who has failed to turn up, if the only way we feel is to make sure that offender turns up is to put a restriction on them, be that a restriction by remand in custody or a restriction in a bail hostel, then again we are saving time and money. Because if they keep failing to turn up, we keep adjourning with a hope that they will turn up, and there's more and more costs there. So we need to be saying, from a financial perspective, we need the opportunity on occasions to restrict their movements, either to stop them reoffending or interfering, or make sure they turn up.
I think I will welcome the government's addition away from breaking the cycle in the bill concerning domestic violence.
Yes.
And I would draw to the committee's attention that we deal with many cases when there is violence against witnesses that is not in a domestic violence, in a domestic situation. And under the bill currently worded, we would not have the power to actually remand that person in custody. And I had a case a couple of weeks ago when the original offence was an assault of by an individual of another individual. Of course, there were some money issues. We remanded the individual on conditional bail not to contact or go near the person that he had assaulted. A week later, he went back round and he assaulted the person again. Now, under the legislation, the new proposed legislation, we would not be able to remand in custody, as clearly there was a need, in my view, to protect that witness.
Fixed penalties. Do you have there's an extension of the use of fixed penalties. Do you have any concern about the type of offences that fixed penalties will be used for? Do you, in addition or in the alternative, have a concern that this is taking matters, you said about public justice, but away from judicial and towards more administrative bodies? Second point. And the third point is, you talked about postcode lottery. Is that because you cannot, as you can with magistrate sentencing, make comparisons between different police officers or different police forces?
If you look at the Coroners and Justice Bill, there was a clause there which said the judiciary must follow sentencing guidelines. So the issue there is we have very strong, stringent guidelines. We can go outside those if it's in the interest of justice. Now, they are public. Everybody knows what those guidelines are for any particular offence. So we are restricted by those guidelines as to how we sentence. There are no restrictions. There are very few guidelines for the use of out-of-court disposals, as they're called at the moment. And we would like to see that there is a place for out-of-court disposals, that they are within very stringent guidelines, and that certain offences should not be dealt with out of court. We believe very strongly that any offence of violence should not be dealt with out of court. Now, the work that the association did under the Freedom of Information Act 2 years ago showed that across police authorities there was wide discrepancy. At the top, in one police authority, 66% of all criminal matters were dealt with outside of a court by fixed penalties, penalty notice for disorder, cautions. At the bottom, it was one authority was 33% were dealt with out of court. Now, I'm not saying one or other is right, but there's significant inconsistency of delivery there. We do know that particular Chief Constable Wiltshire, has actually gone on record in front of magistrates as saying, as far as he's concerned, he only wants 20% of all criminal matters ever to be brought to court. So we have inconsistency there. We have grave concerns. The Chief Inspector's report said that a third of the out-of-court disposals that they looked at had been imposed inappropriately. And in our work, we discovered a figure of 37,000 cautions imposed for what was listed as an offence occasioning actual bodily harm. Look that up in our guidelines and you will see that that is at least a high-level community penalty, if not a custodial sentence. So what we're saying is there is inconsistency of delivery. We need to look at that. There is a place for these sorts of sanctions and disposals, and we need to have a framework, a national framework within which they are operated.
Final question, if I may. If we put those things together, the restriction on sentencing powers, on remand powers, out-of-court disposals, you could add to that, I guess, minimum sentences, and possibly, that's not in the bill, the tax on your allowances as well. How is the magistrate profession feeling now? Profession may be the wrong word. How are you? Is there a feeling that there is a cumulative attack on the discretion, the ability of magistrates to do their job?
I was going to use the word "feel got at," and I think that probably sums it up. Morale is exceedingly low, and we are concerned that all the time it seems to be that it's the magistrates who are being attacked, or their powers, or the work that they do, when no one has shown that the magistrates' work is not of a very high standard. If you look at all the research, the quality of justice delivered in magistrates' courts, and that's been accepted by ministers in the past, and I know the two current ministers who are sitting here do support that principle. And so why is it we want to attack the magistrates all the time? We are delivering high-quality public justice, and unless you can say there are reasons that there's sufficient research to counter that, then please continue to work with the magistracy.
But having said that, John's quite right, morale is low, but we're an optimistic crowd.
Yes.
And we welcome change. We want to be in the forefront of that change, and we want to be involved in change. And that's why today I think we welcome this opportunity to speak.
And we have been around for 650 years, Mr. Chairman, and if John and I have anything to do with it, we will still be around in the next 650 years. And I'm quite happy to come. I'm quite happy to come back to this committee and say so. Please work with us.
Under government plans, I know we're very short of time. You'll be encouraged to impose more community-based sentences. Will the reducing resources for people who deal with offenders in the community affect you in making that decision? Will it be a deterrent to you to impose such sentences? Yes or no would be good in the time.
Yeah. To be very quick, if we want to ensure that we work with the rehabilitation revolution and make greater use of community centres. We've got to ensure that they're challenging, that they're effective, that they have an element of punishment, and things like the intensive alternative to custody and Together Women's Project do. Sorry.
Under the order of the programme motion, I have to bring this morning's proceedings to an end. I'd like to thank you both for coming along, giving your time and evidence to the committee. The committee stands adjourned until 4 o'clock this afternoon, when it will consider further evidence. Order.